Our next case is Gerald Leahy versus Courtney Tyler and others, docket number 24P835. Mr. Grady, when you're ready.
Thank you so much, Your Honor. Your Honors, Albert Grady of Brockton on behalf of plaintiff appellant, in this case, Gerald Leahy. This is a 93A 176D case that was tried, jury waived in Superior Court at Brockton. The plaintiff seeks reversal of the judge's finding on behalf of the defendant. What plaintiff wishes to point out are, for certain dates, are the accident date of August 29, 2016. This is a motorcycle accident, so there is no PIP coverage, personal injury protection coverage, and therefore no set-off under Chapter 90, Section 34M as to the total damages. And on September 10, 2016, in defendant's log, exhibit number 1, determination by the defendant, Progressive, that the insured is 100% at fault for the accident and Mr. Leahy is 0% at fault.
Doesn't this whole case come down to causation?
Does it come, what, Your Honor?
To causation in terms of his injuries.
Well...
Right. Progressive conceded liability right out of the gate. And
yes.
As I read the briefs, the question is, your client's injury, after the accident he said he was fine. There was a long period of time before he then lifted something at work that exacerbated whatever may or may not have happened. And there was a period of time that Progressive was trying to get his medical records, waiting for a release from him. And so once that all happened, then they made the offer at 25. So help me understand what the issue is there.
Well, the issue is this, Your Honor, that 176D, Section 39D, requires the insurance carrier to investigate all circumstances. And 176D, Section 39F, requires the carrier to make a prompt, fair, and equitable claim settlement offer.
So what should they have done?
They
have offered him $25,000 before they knew if his injuries were related to the accident?
No, Your Honor. What they should have done is they set the reserves at about $5,000 and scaled it up. In October of 2017, they were given, Progressive was provided with what is colloquially called a demand package, which is the putting together of the essentials of the damage claim, because as Your Honor points out, that liability is not a factor. And they were given $10,500 in medical bills at that time, and within 2 weeks, they had moved their reserves after receiving that demand package up to $25,000.
But that's not an admission that $25,000 is the appropriate amount to compensate for the injuries caused by the accident. That is a business decision on the part of Progressive that, given the additional information they've received, prudence dictates that they set aside that fund in case it is determined that liability attaches. Are you arguing otherwise?
Well, a bit, Your Honor. I'm saying that the scaling up was a demonstration of the acceptance of the demand package. Now, the demand package does not have the force of 93A.
Why are you arguing that? What do you mean by acceptance?
Well, because they moved the reserves to $25,000 at that time when they had the demand package. October of 2017 for the 2016 accident. Then they were sent a series of letters, and at that point, the claim is the value of the case is $25,000. They have made no offer. They continue to make no offer for the rest of 2017 and into 2018.
Did they have the medical records at that point?
They did have the medical records, and they had more medical records that came in 2018 because an operative procedure was conducted then, and a report was obtained from the operating orthopedist that the motor vehicle accident, which showed from the time of the injury that there was pain in the right wrist, the operative procedure was necessitated by the accident. There was an aggravation of a pre-existing condition. Now, eventually, it's going to turn out, I don't want to skip over the 93A demand. I should pause there. The 93A demand was sent in July of 2018. And the 93A demand had an accompaniment of $23,000 in medical bills at that time, in addition to the new evidence of 2018 where the operative procedure was conducted after the demand package of October of 2017. So now the claimant is high up in damages. In August, the insurance company makes its first offer, and it's $4,137. And what you'll see in the 93A response is an attempt to knock down the plaintiff's medical bills by claiming a reference to some book that was never entered into evidence and has no weight whatsoever. And the upshot is that the defendant, Progressive, never hired any medical person, admitted at trial and through answers to interrogatories that none of its people assessing the case had any medical experience. Now, it turns out that you'll see in this suit, there's a suit against the insured in the complaint, Plymouth Rock and Progressive. Now, Plymouth Rock, and it says right within the count, there's no 93A. That suit is to get arbitration, which you are entitled to in an underinsurance case. Plymouth Rock, underinsurance that is purchased by my client, was for $100,000. By operation of the bodily injury limits, that then exposure for the underinsurance carrier is reduced to $75,000. Plymouth Rock makes offers of insurance. They have the claim much later, a year later, than the bodily injury company, Progressive, had it. Yet they are able to make their offers of settlement, and their offers of settlement as of May of 2018 total $48,000. Now, that's, I submit, is very strong evidence in the case because that is better than any expert testimony. That is how insurance companies are doing things out there in the battlefield where they work. In terms of an underinsurance carrier offering $48,000, that means that underinsurance carrier has assessed the damages of my client on the same record that Progressive has for a total of $73,000. Because you have to take the 25, which is the underbelly of the claim for underinsurance, because there is an exposure, and it was admitted, and it's in the brief, admitted by the defendant. Defendant did not produce any of the adjusters or claims people involved in the handling of the case, but submitted a representative who did admit that $1 of an insurance carrier here for a payment doesn't begin until $25,001. And so they made that offer of settlement. They called up the UIM, the underinsurance carrier, in May of 2018, called up the Progressive and said, what are you doing here? And Plymouth Rock, the underinsurance carrier, said, we had a medical evaluation and it came up with the same thing that Dr. Fanuelli, the operative physician, had, and all the medical bills are not disputed. Why don't you pay the claim? They did not do anything. Progressive did not do anything until November of 2019. I said May of 2018. It should be May of 2019 was when the underinsurance carrier called up. Now, the obligation is on Progressive under subsection D of 176D, section 39D, for it to conduct the investigation. Here, the underinsurance carrier, underinsurance would come after bodily injury, but underinsurance settled first under the aegis that this was so far over the bodily injury that it had its obligation to pay, and it did pay, and it paid first the $48,000. Still, after May, it wasn't until November of 2019 that the attorney engaged by Progressive to represent the insured in the lawsuit that was pending against that insured called up Progressive and saying, what are you doing? You got to pay this claim. If you can still get it for the policy of $25,000, do so. So, at that point, Progressive, never having taken any steps on its own, never having any medical person look at the case, just after the 93A goes through this process of sending out medical authorizations for my client to sign for his prior medical condition, and you'll see at pages in the 200s in the appendix that he also had issues with respect to nightmares and emotional problems that resulted. They're at RA 261 and 262, depression since 2016 motor vehicle accident, patient 2016 accident on motorcycle, has flashbacks, nightmares, reports anxiety and depression. That's within their own records, and that's not even, that's all in addition to the $23,000 in medical bills and the pain and suffering undergoing the surgical procedure with respect to his right wrist. And
when Progressive got the medical records, one of them said something to the effect, and I'm paraphrasing, but that this was a prior client, that Mr. Leahy was a prior client of the facility. Didn't Progressive have the obligation to explore that and see what the prior history was? To see if it was related to this injury? That's
where the rubber meets the road, Your Honor, I believe. And that is, Progressive is to undertake that task under Section D to conduct an investigation. But they can't go on forever. You've got somebody's out of work. You'll see within the brief he filed for
What's the time
bankruptcy.
Period from the time that your client signed the releases to the $25,000 being paid?
Excuse me, Your Honor?
What was the time period from the time your client signed the releases for his records to the payment?
The accident was in 2016, 3 years plus later.
From when your client signed the release?
It was in November of 2019.
And the payment was when?
The payment followed, and there's no dispute that they took too long after. They sent the release.
An answer to my question. When was the payment made after November of 2019?
Within a couple of 3 weeks.
And do we have a case that says that that is an unreasonable time period?
Not the amount of time that it took to send the check, Your Honor. That's not claimed. Also, I should point out that with a 93A case pending, what release does Progressive send out? They send out a release that includes Progressive on the release. Now, this is the judge below characterizes bad faith. Now, there's some evidence of bad faith right there, with Progressive seeking to get itself by paying the insured's policy maximum.
Counsel, unfortunately, I think we're going to have to leave it there unless the panel has additional questions. Seeing none, we're going to have to hear now from Attorney Palumbo.
Thank you, Your Honor.
Thank you.
Good morning, honorable members of the panel. May it please the court. Attorney Palumbo on behalf of Progressive Mountain Insurance.
A little louder, if you don't mind, or pull the microphone closer. Thank you.
I apologize, Your Honor. To get to your first question, Madam Chief Justice, is this case all about causation? We would take the position that it is all about causation. There's really only two issues in the case, and that is if and when liability became reasonably clear, which is the causation issue, essentially, and whether Progressive's investigation was reasonable, which...
So, but what do we do with do you agree, let me just ask you that it was 2 years, it was not until August 2018 that Progressive asked for medical releases?
So I believe that they asked for the releases sometime after the response to the 93A demand in the summer of 2018.
Right, so that's 2 years. Why?
Prior to that, and what the trial court found in the judge's findings of fact as well, is you can see the adjusters are in continuous contact with Mr. Leahy's counsel, requesting records, and they're promised that the records will be forthcoming. Generally, and I believe there was testimony from Progressive's witnesses on this, that plaintiffs' counsels prior to suit, when they're dealing with a third-party insurer, generally don't offer to have their clients sign medical authorizations. They're generally more comfortable with providing the records that they believe support their claim to protect their client's medical information. So that was why they didn't seek the authorizations until that time. They were waiting for those records to be supplied by the plaintiff. So in addition to the issue of when liability became clear, the other issue is the reasonableness of their investigation. And I'd like to address some of the arguments the appellant makes regarding the contrast between Plymouth Rock's investigation and Progressive's investigation. Plymouth Rock being the underinsurance carrier who has different rights to request certain things during their investigation process. As a first-party carrier, they have the right to demand an EOO, demand authorizations, and ask for a independent medical examination. They didn't end up doing an independent medical examination in this case, but they do have all of those rights, whereas a third-party carrier, Progressive, doesn't have the right to demand any of that of the plaintiff. They essentially have to work with what the plaintiff gives them. And I'm not aware of any authority to say that the determination or the settlement of a first-party insurer is dispositive of what a third-party insurer needs to do in terms of the reasonableness of its investigation.
I don't think that's the plaintiff's point. I think my understanding is that the point was Plymouth Rock got the case and boom, they figured it out. They knew there was liability. They settled. It took Progressive forever. So not, in other words, that one of them, that Progressive timeline is governed by Plymouth Rock's, but that Plymouth Rock's shows the unreasonableness of Progressive's.
I see, Your Honor. And I would just like to point out that the timeline isn't actually that far off between when Plymouth Rock settled and when Progressive settled. You can see in the claim notes and in the testimony at trial, Plymouth Rock, in their conversations with Progressive, cited some of the same issues regarding medical causation that Progressive had. That's why they ended up having an independent medical review of the plaintiff's records. And notably at that time, Plymouth Rock had more records than Progressive did. And I'm speaking specifically about May of 2019, when they first discussed the medical records review. At that time, Progressive requested a copy of it, and Plymouth Rock declined to provide it. Progressive's stance at that time was that they needed a full, complete set of medical records in order to conduct their own medical records review, which they still didn't have at that time, as they had only received the authorizations in March of 2019, and they were still some records were still outstanding at that time.
Is it common or part of the usual process for a carrier to engage a medical expert to review records in a case like this?
On a case like this, I would say it is normal when the carrier has questions regarding causation. And in this case, the questions regarding causation from the very beginning were from the fact that the initial record supplied had this reference to Mr. Leahy being a prior patient at the orthopedic doctor, there was a reference to the subsequent injury in the medical records where he allegedly picked up a heavy power tool at work, re-injuring his wrist, and the fact that the medical records after that date cited as the date of injury the incident with the power tool rather than the initial accident. So those were their concerns at that time. Did I answer your question?
Yes, thank you.
Okay.
So turning to the reserve issue, is the definition of reserve a legal question or is it a factual question?
I would argue that it's a factual question, Your Honor. The testimony at trial was that from both Progressive's expert and Progressive's New England claims manager was that when Progressive uses the term reserves and how they define reserves in their practice is that it is their assessment of a reasonable worst-case scenario. I'm not aware of any case law or any other authority that would define it differently as a matter of law.
So he argues in his brief that the judge should have admitted F for identification as an exhibit and that it had the Progressive logo on it and it gave a definition of reserves that one could argue are different from what you just said. What's your response to that?
So I think that issue, the standard of review on that issue would be abuse of discretion, and I think the judge was well within his discretion not to admit that as an exhibit. First off, I believe defense counsel had objected to that being admitted as an exhibit based on the fact that it had never prior been produced. And the other issue, too, was that neither of the witnesses that were shown this exhibit could properly authenticate it. The rules require authentication to prove that a document is, in fact, what it purports to be. Both of the witnesses essentially said, I've never seen this document before. I'm not familiar with any of the principles within the document that I'm being asked about. So I would say that the judge properly exercised his discretion in excluding that. So in addition to the issues regarding causation, there's this whole issue of whether or not Progressive conducted a reasonable investigation. I think the facts on the record pretty much speak for themselves. Progressive was in constant contact with plaintiff's counsel, seeking records. They were clear in their 93A response as to what records they were seeking, and their responses prior to that, they were clear about what records they were seeking. Like I said before, there's a clear difference between the rights of a third party and a first party insurance carrier, and they worked within their means of what they could, reasonably demand from the plaintiff and what they were provided with. And I think the trial court's determination that until the time the counsel that Progressive had hired to represent an insured had contacted Plymouth Rock and spoke to their counsel and obtained a summary of the records review directly addressing the issue of causation, of medical causation. Until that time, there was liability was not reasonably clear because, as you know, 176D requires that liability encompass both damages and fault. So from the very beginning, the issue of fault really wasn't the problem. It was all this issue of causation. those were the points that I wanted to cover, Your Honors, if you have any additional questions.
Seeing none, we can certainly take the rest of your points on your brief. Thank you very much, counsel. The case is under advisement.
Thank you, Your Honors.